All right, good morning, everybody. Just coming in today to finish up Chapter 15, the federal courts. I promise I will not take as long as I did the last time. And so if everyone would get their notes out, turn to letter E, implementing court decisions. We will begin. 57 minutes was way too long for the last round. So I'm going to try and cut this down to about 15 minutes here. And then if you have questions, we will meet at the end of the week, and you can ask me questions at that time. So we're going to pick up with letter E, implementing court decisions. Supreme Court decisions, they're not self-implementing. As you can imagine, and go back to Andrew Jackson with the Trail of Tears. Supreme Court decisions, when the Supreme Court makes a decision, it doesn't automatically mean that it's going to be implemented or carried out across this country. So if you're looking at number 3, refers to how and whether court decisions are translated into actual policy. That is judicial implementation. The vocab term for that is judicial implementation. And for implementation to occur, there has to be several elements. There has to be an interpretation population. Those are the judges and lawyers across the country that can read through the hundreds of pages that could be of majority opinion and make sure that the majority opinion is understood and being followed, and the intent of our Supreme Court is understood. Then there's an implementing population, and that implementing population is typically government. The implementing population is whether it's state government or federal government, whether it's Congress or someone in the bureaucracy. They're those men and women who are dealt the task of actually implementing the public policy. So we think about Brown versus the Board of Education. And in Brown versus the Board of Education, everyone understands that Brown versus the Board of Education, segregation is unconstitutional. It violates the 14th Amendment Equal Protection Clause. And in Brown versus Board of Education, there had to be an interpretation population, which were the judges across this country, lawyers across this country. But then the implementing population is going to be the Department of Education. It's going to be the Department of Justice that are going to force schools across the country to desegregate. Lastly, there has to be a consumer population. The consumer population is you guys. It's the men and women across this country that understand their constitutional rights, and when they feel like their constitutional rights have been violated, they stick up for their constitutional rights. They form lawsuits, and they understand what the court has laid out in front of them in terms of their protections. Next, letter F, the debate over original intent. So, a contentious issue involving our court's role in judicial discretion is how our Constitution is interpreted. What does the Second Amendment mean to you? What does the Fourth Amendment mean to you? How is our Constitution interpreted? And it can be different amongst individuals, judges across this country. And so looking at number 2, some have argued for what is called original intent. And original intent is also known as strict constructionalism. It's also known as strict constructionalism. Strict constructionalism or original intent, they are individuals, men and women, who are judges across this country who view the Constitution through the eyes of our founding fathers. They view the Constitution as a document in which what is written is what is meant. And so strict constructionalism or original intent, they are justices across this country who, when they're looking at how to interpret, what discretion do they have? How are they going to interpret the meaning of the Constitution in their relevant court case? They are looking at what the original intent of our founding fathers was when making their decision. Now, not on the notes is the opposite of strict constructionalism, and that is loose constructionalism or liberal constructionalism. These are justices that view the Constitution as an ever-changing document. Excuse me. They view the Constitution as constantly evolving, and what is written might mean, and how they interpret it might mean something different. And so when you're looking at original intent, strict constructionalism versus loose or liberal constructionalism, oftentimes you can play it out a little bit in terms of ideology. And it's safe to assume that more of our major conservative justices have much higher original intent or strict constructionalism. And many more of our more liberal justices, West Coast justices that are serving in West Coast courts, or um, New England state justices have much more of a loose or liberal viewpoint in how they view the Constitution. Okay, the next section, the courts and the policy agenda. The courts reflect and help to determine our national policy agenda. And then we're going to break it down into a couple eras here. Up and until the Civil War, the dominant questions before the court regard the strength and legitimacy of the federal government and as well as slavery. And so issues that were dealt with by the Supreme Court were just ironing out federalism, supremacy. Let's go back to some cases that you guys know pretty well during this time frame. Up until the Civil War, what are some cases that you know well? Well, you know Marbury versus Madison. What's that doing? Identifying the role of our federal court, filling in the cracks. McCulloch versus Maryland, right? Implied powers, supremacy clause. Gibbons versus Ogden, commerce clause. And so up until the Civil War, the predominant questions that were being determined by our bench, by our Supreme Court, were questions of federalism. Now, from the Civil War until 1937, questions surrounding or decisions made by our Supreme Court really dealt with the economy. And as we're looking at this time frame, the Supreme Court's going to make a lot of decisions during and through that industrialization time frame that are going to be economic decisions. And we look at up until, when I say 1937, we're really getting into the early years of the New Deal legislation. And during this time frame, courts traditionally favored corporations, even when government tried to regulate them. And then really since 1938 and even today, our courts have concerned themselves with personal liberty, social equality, and political equality. And as we go through the court cases, the 15 required, and the many, many, many more court cases if we were in class that I'd be real briefly talking about, this is the time frame of civil rights and civil liberty. Expansion of your First Amendment, expansion of your Second Amendment, expansion of your Fourth Amendment and Fifth Amendment and Sixth Amendment and Eighth Amendment. As we look during this time frame from 1938 to present, really what our court has spent the bulk of its decisions on are expanding civil rights and civil liberties. Okay, we know the Chief Justice from 1801 to 1835 was John Marshall. We know that John Marshall was the Supreme Court Chief Justice during the time frame of Marbury versus Madison. Marbury is a case that you guys should be very familiar with, so I'm just going to move down through this real quick. Letter C, Marbury and three others sued Madison, asking the Supreme Court to issue a writ of mandamus, which was a power that was granted to the court underneath the Judiciary Act of 1789. And as you guys know, that the Judiciary Act of 1789 is going to be ruled unconstitutional by the court. Marbury, if you look at letter B, Marshall will assert for the courts the power to determine what is and what is not constitutional and establish the power of judicial review, and that is very important. As you guys know, the Supreme Court today, most of what the Supreme Court accomplished today is judicial review. A couple other important benches here. FDR, when FDR entered the White House, obviously we were in a depression. FDR was going to change the game in terms of the role of government. The role of government in addressing the economy with his New Deal legislation. The Supreme Court had declared multiple acts of FDR to be unconstitutional. Roosevelt had had enough of it. And so Roosevelt proposed the court packing plan. And so in 1937, Roosevelt proposed what is called a court packing plan. The court packing plan was to increase the size of the Supreme Court to 15 justices. He would get to appoint all 6, thus giving a majority of the justices that he would want, and would be able to move forward with New Deal legislation. Just in time, we call it switch in time that saved 9. The 9 old men, which are referencing both their ages of the justices and their political philosophies, decided to jump on board with FDR's New Deal policies to keep the bench at 9 justices. Now, letter D, I cannot stress this enough. The most active, liberal, expansionary bench that we have ever had is called the Warren Court. And again, these names, the Warren Court gets its name because the Chief Justice was named Earl Warren. Earl Warren served from 1953 to 1969. And this is the time frame in class where I would just start throwing court cases at you and expansions of civil liberties and personal freedoms, defendants' rights. But I cannot stress this enough, that Earl Warren, the Warren Court, expanded civil liberty, expanded personal freedoms, expanded rights of the defendants, really applied our Bill of Rights in providing more constitutional protections for people across this country than any court in American history. They are the most judicial active court. Earl Warren was most definitely a loose or liberal constructionalist. And as you guys kind of read through here, the court is really going to start with Brown versus the Board of Education. Then the court will expand the rights of criminals and defendants in numerous areas. Baker versus Carr, which is a phenomenal case that we're going to get into, is going to order that one person, one vote ruling where population has to be equal and states are going to be required to redistrict consistently. Earl Warren, through protecting religious freedoms to First Amendment freedom of speech and press, the Warren Court did a lot to Fourth Amendment, Fifth Amendment, Sixth Amendment, did a lot to expand personal freedoms. The Burger Court, 1969 to 1986. The Burger Court, Nixon, this is the funny part here, Nixon got to put on a new Supreme Court Chief Justice. Nixon thought he was going to do it the right way. So he nominated Warren Burger. Warren Burger and the Burger Court will be a little bit more conservative in their rulings than obviously the Warren Court. However, not terribly. You look at some cases under this time frame, the Burger Court was still very progressive. The Burger Court made rulings on Roe versus Wade, U.S. versus Nixon, did not overturn fundamental rights established earlier under the Warren Court in cases like Miranda versus Arizona and Miranda rights. Did not overturn a lot of due process protections that the Warren era offered and set as precedent. And so the Burger Court, Nixon really thought he was going to get a conservative justice on, start chipping away at the Warren Court, and it simply didn't turn out that way. The Rehnquist Court, however, will. In the Rehnquist Court, William Rehnquist, who will be put on as Chief Justice of the United States Supreme Court by Ronald Reagan, and the Rehnquist Court will. The Rehnquist Court will start chipping away at previous decisions that were made under the Warren Court. Will start chipping away at previous decisions that were made under the Burger Court. It wasn't a revolution in constitutional law, but it was just, 2 decades of just slowly chipping away at rights of abortion, affirmative action, defendants, et cetera, et cetera. And if you guys want to, on Thursday or Friday when we meet this week, I can explain these courts a little bit more. Our current Supreme Court Justice is John Roberts Jr., the Roberts Court. John Roberts became Chief Justice of the United States Supreme Court in 2005. He was put on the bench as Chief Justice by George W. Bush. And the Roberts Court has been kind of unique. It's been a 5-4 court, mainly conservative, five more conservative justices, 4 more liberal justices, or more progressive justices. But John Roberts and another specific conservative justice have flipped back and forth in making their rulings. And so John Roberts in our more conservative court has chipped away at certain things. They did make the Citizens United decision. The Roberts Court has chipped away at the rights of labor unions. The Roberts Court has chipped away at certain defendants' rights. However, the Roberts Court also upheld the constitutionality of the Affordable Care Act. The Roberts Court also ruled in Obergefell that individuals have, same-sex individuals have the right to marry. So although this court has been nowhere near as conservative as the Rehnquist Court. Okay, one last major discussion here, and very important discussion here. What courts should do, the scope of judicial power. There are strong disagreements concerning the appropriateness of allowing the courts to have a policy-making role. What role should the court take? How active should the court be in the cases that they decide to hear, and then the decisions that those courts make? And so looking at number 2, many scholars and judges favor a policy of what's called judicial restraint. Judicial restraint. Judicial restraint is the belief that the courts should stay out of policymaking, that they should leave decisions on public policy to Congress, to the president, and only hear cases of major national concern, controversy, or crisis, called judicial restraint. The opposite of judicial restraint is what's called judicial activism. And by the way, let me go back. Justices that believe in judicial restraint will take certain issues in society and believe that those issues in society really do belong to our legislatures, and that they just kind of want to stay away from making decisions and allow the legislatures to handle certain issues, such as abortion, school prayer, etc. Those justices that believe in more judicial restraint feel that they're more referees than anything else across the country. Now, the opposite side of judicial restraint is called judicial activism. And that's the fill-in for number 4. Judicial activism is the belief where judges should make bolder policy decisions. They should break new constitutional ground. They should seek out cases that will expand constitutional protections across this country. So when you're thinking of judicial activism, yes, you must think of the Warren Court, the Burger Court. Judicial activism, and the concept behind judicial activism, is that the courts can alleviate needs for those who are weak, those who might be weak economically, those who might be weak politically, that they can stand up and they can protect those individuals that are finding no luck in getting government to protect themselves. So we have judicial restraint, judicial activism. Judicial restraint, judges should be more referees, stay out of a policymaking role. Judicial activism, judges should be more open to hearing new cases and setting new groundbreaking precedent to alleviate needs of society. They can serve a policymaking role. Okay, a couple more things here. Oh, sorry. How the court sets limits on the cases it will hear. Our federal courts have developed a series of political questions as a means to avoid deciding certain cases. Typically, conflicts between the president and Congress. I will tell you this: the Supreme Court of the United States tries to stay out of political questions. If there is a dispute taking place between Congress and the president, our courts typically try and stay out of deciding political controversies or political questions. They want to avoid deciding cases. Judges attempt, whenever possible, to avoid deciding cases on the basis of the Constitution that show a preference for less contentious technical grounds. So today, the courts have 4 things that they put out there. There's 4 different criteria that the courts use to determine, is this a case that we're going to hear? So number 1, jurisdiction. Do we have the authority? Number 2 is mootness. All right, so we're looking at number 3. The courts employ issues of jurisdiction, mootness, M-O-O-T-N-E-S-S. Is there contention here? Is there standing? Is there constitutional ground? And lastly, it's called ripeness, R-I-P-E-N-E-S-S. Is this court case ready for us to hear, or does it need to be settled in a lower court first? So jurisdiction, mootness, standing, ripeness, political questions, those are all criteria that our bench uses to make decisions on what cases that they're going to hear. Okay. As we're looking at courts that can be too active, step out of line, courts that are maybe seeking out cases that are negatively impacting, Congress and Congress's vision or the president's vision. Basically what we're looking at here is what checks do we have on the Supreme Court? What are the checks and balances that fall under the Supreme Court of the United States? How does Congress check the power of the bench? How does the president check the power of the bench? And you got to remember, Supreme Court justices, they serve for life. Their decisions are binding. So what happens if the court starts stepping out of line, maybe is too active, or maybe the court is expressing too much restraint? Well, you guys know, number one, we do have impeachment and removal. If justices are taking bribes or conducting some kind of decisions that would fall under misdemeanor or high crime, they can be impeached and removed. But as you also know, that's rare and unlikely to happen. So what can Congress or the president do if the Supreme Court makes a decision that they feel is negatively going to impact them? Well, they get to determine who sits on the bench. So when there's an opening, put someone on who is going to change the court, flip the court around. That's important for letter A. But letter B, don't forget, if the Supreme Court makes a decision, there's only two ways to change that Supreme Court decision. A future Supreme Court decision overturning it, which, as we know, is very rare and doesn't take place for decades down the road. So if a decision is made that is a negative decision in the eyes of Congress and the president, what can government do to check the power of the court? They can ratify a constitutional amendment. Congress can propose it with 2/3 vote in the House and the Senate, and we can get 3/4 of our state legislatures to ratify it. That is a big check and balance that the Supreme Court has, that Congress has over the Supreme Court. Other areas, if the Supreme Court denies or rules something to be unconstitutional, the president can simply issue an additional executive order. Look through President Trump's travel bans. Travel ban 1, 2, 3 ruled to be unconstitutional. Travel ban 4 acceptable. So keep writing your executive orders. Keep changing around your executive agreements. Congress, rewrite the law. And so we call letter D, at times, it can be the issue of what's called statutory construction, where the Supreme Court might declare a law to be unconstitutional. Congress simply can just rewrite that law, right? Rewrite it in a method that the courts would find acceptable. So there are checks and balances that we do have over our federal courts. All right, just kind of going down through here and finishing up with some stuff. Sorry. Come on. Okay. All right, you guys can see how we have what's called a dual court system. Our state courts mirror our federal courts. We talked about constitutional courts. We have 3 levels of constitutional courts. We have district courts, which are our trial courts, circuit courts, which are our courts of appeals, and then the Supreme Court. States have the same thing. We have Court of Common Pleas, we have circuit courts, and then we have state Supreme Courts. And the U.S. Supreme Court is unique because it can hear cases appealed by either the state or federal level. Same thing here, right? On the left, on the very left here, we have our circuit courts. In the middle, we have our state courts. On the right, we have our legislative courts. Just some information about the different types of federal courts we have. More information about the different types of federal courts we have. These are our circuit courts. I showed you that the other day. Don't forget, we have 94 district courts. We have 13 circuit courts. We have 1 U.S. Supreme Court. And that's pretty much wraps up this chapter. I hope you find this useful, and I'm looking forward to talking to you guys face-to-face at the end of the week.